So Sandra, I'm going to go ahead and give a little pre-meeting talk, if that's okay, since we're just approaching 6:30.
That's fine.
Sounds good. Welcome, everyone. If this is your first time joining us, everyone will remain muted throughout tonight's presentation except committee co-chairs and presenters. Following the presentation, co-chairs will have the ability to call on members of the public that wish to speak. At that time, you can participate by going to the reactions icon and pressing raise hand, but not the wave or thumbs up buttons. Only press it once, because if you press it a second time, your hand will go back down and we'll miss you. If you're on the phone, it's *9 to raise your hand and *6 to unmute. And be on the lookout for a prompt at that time asking you to confirm unmuting once the co-chairs call on you. Please note the chat is for technical support only to help with Zoom software problems and not to ask questions of the co-chairs. Finally, if you have an older version of Zoom, you'll need to go to the participants section where you'll find the raise your hand feature. And finally, do not raise your actual hand or wave at the camera because the co-chairs might not be able to see you.
You still have several people signing in, so you may want to give it a moment.
Okay, great.
Thank you.
I've been having connection problems, so I might need to sign in on my phone if this doesn't go well.
I hear you. I hear you. I'm hoping I'm good tonight too. So, oh goodness, right? The weather and everything else, right?
Right.
Ryan, just introducing you really quickly to Sandrea Coleman and Sarah Chu, who are our co-chairs today. And Max is our assistant district manager who will be doing the behind the scenes work behind this meeting.
Pleasure to meet everybody.
Yes, greetings, Ryan. Welcome. Thank you.
Thank you. Thank you.
Just one more, about 1 minute. Not signed in already, so that's good. Give it another minute.
Sure. Yeah, I just saw several more board members just arrive, actually.
Mm-hmm. Okay, we'll get started. So, greetings all and welcome to CB8 Manhattan Social Justice Committee meeting on tonight. Also, they thank you everyone for showing up and co-chair, my co-chair, I'm her co-chair, Sarah Chu is here with us as well. I would like to ask Max just to give his speech again on instructions because some people did sign in a little later. So if that's okay.
Sure. Yeah, I can certainly do that right now, actually. So welcome everyone, those of you that just joined. If it's your first time joining us, everyone will remain muted throughout tonight's presentation except committee co-chairs and presenters. Following the presentation, co-chairs will call on members of the public that wish to speak. And at that time, you can participate by going to the reactions icon and pressing raise hand, but not the wave or thumbs up button. Only press it once, because when you do press it multiple times, your hand will go back down and we may miss it. If you're calling from the phone, please press *9 to raise your hand and *6 to unmute. And please be on the lookout at that time for a prompt asking you to confirm unmuting once the co-chairs call on you. Please note the chat is for technical support only, to help with Zoom software problems and not to ask questions of the co-chairs. And finally, if you have an older version of Zoom, you'll need to go to the participants section at the bottom of your screen where you'll find the raise hand feature. And lastly, please don't raise your actual hand or wave at the screen because we may not be able to see.
Thank you, Max.
Sure.
So we have Ryan here. Ryan, you can introduce yourself and start your presentation to us, workshop that you came out to give us and inform us with, please.
Absolutely. So first and foremost, just thank you to everybody for having me here tonight. It's always a pleasure, to be able to present this information. It is really important information to make accessible to New Yorkers. So I definitely appreciate the opportunity to be here. So my name is Ryan Dubois. I'm an associate human rights specialist with the New York City Commission on Human Rights. We'll get into a lot more detail about the agency and what we do, but speaking very generally, we are a law enforcement agency that enforces the city's anti-discrimination code, otherwise known as the New York City Human Rights Law. So my understanding is that, we have like an hour and a half to 2 hours tonight. The presentation that I'll be presenting with using a PowerPoint, it is very information dense. It's a bit lengthy and heavy with regards to the thoroughness of the law that we'll be reviewing. But so folks can definitely let me know throughout the presentation if there's particular areas that you like to focus on. You can always interject with questions and clarifications. I would definitely like to make it, to the extent that you would like to engage with the presentation, to make it a dialogue rather than just a presentation. I'm definitely open to that because of course I want the information to be as accessible as possible. So with that being said, I'm gonna go ahead and share my screen and we'll go get started.
Great. Ryan, maybe a way to facilitate questions while you're presenting is to give us a sense of the major topics you're going to cover. And that way, if let's say we have a lot of interest in topic number 2, we at least have a sense that we still have to get through 5 and 6.
Yeah, absolutely. So fortunately, in the very beginning of the presentation, I'll basically be giving it a general outline of the material. And so that will include primarily a breakdown of the law. So there's primarily 5 areas of the law that we'll cover. The 2 really most dense areas of the presentation are employment and housing. So if based on the outline of the presentation in the beginning, you'll have a very clear sense of what we'll be discussing. So if there's areas that you are interested in moving forward through a little more quickly, and others that you want to spend a little more time on and focus on and do a little more question and answer, definitely just feel free to let me know. Folks can interject with questions, or of course using the chat feature, raise hand function, all of that. So however folks want to interact, it's fine with me.
Great, thank you.
No problem. All right, so let's get started.
You should already have capabilities to share.
Yep, I do.
Okay, cool.
Thank you.
Yep.
Just one thing to note as well, just based on the kind of the breakdown of the slides, I tend to sometimes speak out of order of the slides, just because it's kind of just a natural way to dialogue around the issues based on the material on the slide. So if I skip through slides, we're not skipping information. I'm just trying not to be redundant.
Thank you.
Okay, so just looking at the agenda for today's presentation. So we're going to be doing an overview and of the history of the commission, so how the agency came to be, looking at protections against discrimination under the city human rights law, and of course how to contact the commission, because our resources are of course are only as valuable as people's ability to actually access them. So how to contact the commission, as well as what does the process look like if somebody does file a complaint with us. So as I mentioned, the Commission on Human Rights is the city agency that enforces the city's human rights law, and we are also charged with educating the public on their rights and responsibilities under the law. So before the commission was a city agency, we were what was called the Committee on Unity. And I like this quote because, you know, it really speaks to the mission of the agency. Of course, as a law enforcement agency, we do represent particular individuals that have experienced discrimination, but that's part of course, a larger mission for the values of the city. So this quote here is from Mayor LaGuardia, who created the initial Committee on Unity in 1944, which is to make New York City a place where people of all races and religions may work and live side by side in harmony and have mutual respect for each other, and where democracy is a living reality. So again, we're really talking about these concepts of how we view ourselves as a society in New York City as a pluralistic democracy. And something really important to note as well is that in the context of what we're seeing with the socio-political situation in New York City, it's actually extremely relevant to how the Committee on Unity came to be. So this committee was actually established in relation to riots that occurred in Harlem in reaction to a police shooting of a Black man who was actually also a returned Army veteran. So the Committee on Unity was essentially established to address, the racial tensions that were resulting at that time, in particular with regard to interactions with law enforcement. And I think that's extremely relevant to note. In 1955, Mayor Wagner named the committee a full city agency. At that time, it was named the Commission on Intergroup Relations. And then in 1962, it received the name Commission on Human Rights. And throughout this history, it's also important to note that the commission has not been static in its agenda and in its powers. Similar to the US Constitution, the New York City Human Rights Law is a living and breathing document, which is constantly receiving, analysis, critiques, and also updates in order to adapt to, potential historical shortcomings, as well as more recent and current socio-cultural and political developments. So, what is the commission? How do we function as an agency? We enforce the law. What does that look like? So we break down basically into 4 different departments. Number 1, the Community Relations Bureau. So like many city agencies, the commission is charged with having a community engagement entity. And so that is the Community Relations Bureau. So essentially, as I mentioned earlier, as a city agency that offers these services, the services are only as valuable as they are able to be accessible to the public. So it's our job, essentially, myself working with the Community Relations Bureau, it is our job to essentially be the link between the attorneys and the people who need the resources. So unfortunately, we know that many people have never heard of the Commission on Human Rights, or maybe they have heard of us, but they don't know exactly what we do. Maybe they know what we do, but they think that they would have to pay to receive legal representation. The truth is that we are here to serve New Yorkers, and all of our services are completely free. So we educate about that primarily through, workshops such as these. Of course, this is our kind of general human rights law workshop where we'll cover different areas of the law. We also have more specific focused presentations geared towards the rights of the LGBTQ community, geared towards the experiences of the Muslim community, looking at race and color discrimination, youth-oriented programming. So really looking at, who is most in need or could benefit the most from these services, and targeting our education outreach accordingly. Other than presentations, we also have a lot of different programming that we do as well. We may host cultural celebrations. We may do what we call intergroup relations work. So if we know that there are historic tensions between particular groups, or if we know that a particular group has been substantially historically marginalized, we may do events to uplift that community, bring attention to their situation or their cultural celebrations, etc. So, really it's a very wide and amplified mission with a lot of, it's a multi-pronged approach that we have to do this community outreach work. With regard to the Law Enforcement Bureau, of course, you can tell by the name that this is where our attorneys reside. As I mentioned, our services are all completely free. We do help many individuals get very concrete, tangible benefits primarily looking first and foremost about how to get justice for that individual who has been discriminated against, but also taking, to the extent that it is possible, a more restorative justice approach, and also looking at not only the situation of that particular individual, but also what kind of mechanisms can we establish to ensure that this type of discrimination does not continue to happen into the future. And that, along the way, we're also creating cultural shifts within organizations, whether that be, corporations, small businesses, government agencies, which are also within the jurisdiction of the law as well. So this is the mission of the Law Enforcement Bureau. The Office of Mediation and Conflict Resolution. If there was to be an instance where the party who had committed the act of discrimination was willing to come to a settlement without having to fight it out via litigation in court, then this would be the responsibility of the Office of Mediation and Conflict Resolution to basically bring the two parties together and create a solution that's fair and just for the individual or group that was discriminated against. And to ensure, like I said, that the entity that committed the act of discrimination provides justice for the individual, and also ensures that in a sustainable way moving forward, they will implement new practices to ensure that that type of discrimination does not happen again. And then finally, we have the Office of the Chair. This is where our policy department resides. This is also where the commissioner herself resides. This office actually has the power to issue final decisions and orders in legal cases. So the Office of Administrative Trials and Hearings is where our attorneys operate. The judge in those cases actually issues a recommendation, which generally would be the default ruling, but the commissioner actually has the ability to either overturn that ruling or change or adjust the penalties. We also have the ability to issue legal guidance. So in the instance that there is a gray area with regard to the enforcement of the law, we can issue a legal guidance to clarify exactly how the law is interpreted. We can draft policies and legislation, which, as I mentioned, the human rights law is a living and breathing document. So that's the function there. And also engaging policy discussions with commission stakeholders, because of course, as a government agency, we also want to be directly involved with the advocates and community members and directly affected populations to ensure that we are adequately representing them in our advocacy.
Right. A question about the law enforcement end of things. Does that bureau do both civil and criminal litigation? That's my first question. My second question is, does it represent New Yorkers if they have complaints against another city agency?
Yeah, so to the first question, we do not operate in criminal court at all. The Office of Administrative Trials and Hearings is strictly a civil court. So criminal matters would be outside of the purview of the Commission on Human Rights. With regard to the second question, other government entities, yes. So New York City government agencies are within our jurisdiction. So, think DOE, Department of Transportation, etc. A state or federal agency operating within the 5 boroughs would not be within our jurisdiction.
Great, thank you.
Just a few things to note here. The community service centers, those are offices that we have in each of the 5 boroughs to ensure that our services are accessible to individuals who don't feel like they have to, travel across the whole city in order to be able to walk in the door and speak with somebody. Of course, those offices are closed now due to COVID, but in an instance where it would be, safe and not jeopardizing to anybody's health to have those offices open, people would be able to access those resources there. Our central office is in Lower Manhattan. This is where our Law Enforcement Bureau is located, as well as the Office of the Chairperson and Policy Department. And here it just mentions that you can call 311 to access our services, which is true, but we also have more direct contact information, which is in a later slide. So this is what I was referring to in particular with regard to the different areas of the law that the presentation will be focusing on. So we do break down the law that we enforce into 5 different areas. Discrimination is prohibited in employment. So, just summarizing very quickly, we're basically talking about hiring, firing, and unequal treatment in the workplace. Public accommodations, which essentially refers to any place that would offer goods and services to the general public. And that can be a government offered service or a private institution. Housing, of course, fairly self-explanatory. Seeking housing, being evicted on a discriminatory basis, unequal treatment within the housing that you may already be dwelling in. Discriminatory harassment, we're talking about violence or threats or intimidation on the basis of discrimination, basically any form of interfering with somebody's ability to safely enjoy their constitutional rights. And bias-based profiling by law enforcement, which also kind of speaks for itself based on the title, basically talking about discriminatory treatment by law enforcement entities. And again, these are specifically New York City law enforcement entities that are under our jurisdiction. We do have a statute of limitations, or in other words, the period within which somebody can report an act of discrimination before it essentially expires and they can no longer file a complaint. For the vast majority of instances of discrimination, that's going to be a 1-year statute of limitations. So you have 12 months from the time of the last act of discrimination. So if you have been experiencing ongoing discrimination for the past 2 years, as long as the last act of discrimination occurred within the past 12 months, you can file that complaint and we can still take into consideration everything that happened on the whole 2 or 3 years prior. But if the last act of discrimination was to happen 13 months ago, unfortunately, that would be beyond the statute of limitations, with one exception, which is regard to gender-based harassment. So due to a law passed by the City Council, which is called the Stop Sexual Harassment Act, there is an exception in the human rights law that the gender-based harassment form of discrimination actually has a 3-year statute of limitations. In the instance that you did miss the statute of limitations to file with the City Commission on Human Rights, there is also a state division on human rights as well as state courts where you could pursue a discrimination claim. So discrimination, we all generally understand what it is, but we also may have our own ideas about what exactly that looks like. So we have our own official definition as the Commission, which is unfair or unequal treatment of a person or group based on certain characteristics or membership in a protected class, such as race and color. Protected class is a very key legal term here that I'll be referring back to a lot. Protected class essentially refers to those groups designated as protected under the law. So here we use race and color. Some others that people may intuitively think of would be gender, sexual orientation, gender identity, religion, disability, etc. But there are actually 27 protected classes under the law. And so we're going to look at exactly what those look like in detail. We also know that discrimination is multidimensional. So it's not always so clear-cut, straightforward, black and white as, one person discriminating against another person for one particular reason. Sometimes, our identities can be intersectional, and discrimination can be intersectional as well, essentially meaning that our various identities interplay in such a way that I may be discriminated against because I'm an immigrant and because of my sexual orientation. I may be discriminated against because of my gender and my race. So there's various different ways that discrimination can occur and different reasons that they may be occurring and various reasons simultaneously. So we take that into consideration when we're analyzing a case.
Ryan, sorry, Ryan, it's Andrea. Can
Sure.
we pause for a second? And I see Jordan has his hand up. I hope that's, I'm not sure, but Jordan has their
Thank you
hand
very
up.
much.
If they can be
On the
unmuted to ask a question.
Sure.
Thank you.
On the previous slide, the 5th box mentioned law enforcement. What is your relationship with the CCRB, which also seems to deal with bias-based profiling, in particular by the NYPD?
Right, so this is a good question. So the CCRB is the entity that I would feel pretty comfortable saying receives the majority of complaints that people do pursue against law enforcement. I think that's partly because they're a longer standing institution. The bias-based profiling by law enforcement is a relatively new area of the human rights law. So the CCRB is an entity that kind of is more established in that realm. And I think also has actually a little bit more enforcement capability. With regard to the human rights law, just being completely honest and transparent with you, that's actually one of the weaker areas of our law. So in each of the other areas of the law, we can issue financial penalties, which includes fines to the city, as well as potentially financial settlements to the individual where that may be, justified or necessitated. That's actually not the case with regard to bias-based profiling by law enforcement. So the extent of our enforcement capabilities there is to issue a recommendation. We cannot issue fines to the city. We cannot issue settlements with individuals. And our recommendations are subject to the approval of the police commissioner. So for that reason, folks tend to generally go more to the side of CCRB. but that's kind of the nature of that dynamic.
Thank you. Just so you know, the CCRB doesn't make any decisions. It makes only recommendations, and the police commissioner acts on them one way or the other. Thank you for explaining that.
Sure, no problem. Yeah,
I have
oh yeah, no, go ahead.
Oh, I have a question too. Listening to what this agency details, what about when someone has an EEO complaint and they take it like to the federal level? I know that's a difference, but can they do both? Or is it one? Like, you know, when people have issues with employers and they go to the EEO, with federal, even with NYPD and stuff like that. I'm just curious, because I've always heard EEO most of the time. No one really promoted, you know, this. So I'm just curious about that and why.
Yeah, absolutely. So I don't have as detailed knowledge about how EEO works, but what I do have knowledge of is the EEO in relation to our law. So the short answer is a person can really only have one claim at a time. So I cannot file with the New York City Commission on Human Rights and say, well, just in case that doesn't work out, I'm also going to file a federal complaint via the EEO avenue. That would actually not be permitted. Person can only have one case for that given issue operating simultaneously. Now, we do generally recommend that folks take the avenue of the City Commission on Human Rights, and the reason being is that the city human rights law is actually one of, if not the most thorough and expansive civil rights protections in the country, which enjoys protections that just simply don't exist in other jurisdictions. So number one, it'd be more likely that the case will be accepted in the first place. And also because we are a local agency, also our staff, our resources are generally more accessible to residents of New York City. Now that being said, I'll also clarify. So within an organization, using a city agency, for example, there are often there's like an EEO team, EEO representatives that may field an initial complaint. So let's say an individual makes a complaint to their EEO representative about an issue that they've experienced. At that stage, there's no legal case that's been initiated. There's an initial complaint internally within the organization, and they have the ability to operate, to take action on it or not. If they were to take adequate action, but the discrimination still persisted, then the individual can proceed and file a complaint. Now, at that juncture, the employer may not be responsible if they, like I said, if they have taken some type of action to address the issue. Now, if the person were to file an EEO complaint and the employer did not take adequate action, or they tried to dismiss the complaint, or they tried to, quiet the individual, and then they filed a complaint, whether it be on a federal level or a city level, et cetera. I'm just clarifying that the employer actually would also be potentially liable for the discrimination at that point. In the example of sexual harassment, let's say I report sexual harassment. The employer attempts to intervene, the harassment persists, I file a complaint. The employer may be able to show that, well, we did take actions to combat the issue. If the employer were to say, oh, it wasn't that big of a deal, this person is just like that, or, somehow try to avoid the issue rather than settling it, the employer would also potentially be liable in a lawsuit in that instance. So I just want to throw that in there as well.
All right, thank you. Alita Camp has her hand up.
Thank you, Sandrea. Thanks, Max. I just have a question about housing discrimination. Do you work with people who are disabled and the building won't provide them access in or out of the building? There are a couple of steps down in their wheelchair. Do you work with the resident in that business?
We do, and we actually have a specific unit in our law enforcement bureau dedicated to that specific purpose, but that actually has its own section in the presentation. So I'm going to table a more detailed answer until we get to that portion. And I think all your questions will be answered at the juncture.
Thank you. Don't want to jump the gun. Thank you.
No, not a problem. Not a problem. All right. If there are no more questions, we will proceed at this juncture. So just a note on establishing when discrimination has occurred. So of course, there must be the party who discriminated and the party which was discriminated against. That can be the employer being discriminated against by the employee, the tenant by the landlord, the customer by the public accommodation. So we have to establish that relationship as well as the protected class, which was the basis of the discrimination. So moving on into the area of employment. So something important to note about our protected classes is that some protected classes will apply universally to the law. Other protected classes may only apply in a particular area of the law. So for example, we have protected classes which are established specifically for the area of employment that, for example, will not apply to housing. An example, one of our most recent protected classes is pre-employment marijuana testing. That is a specific protected class in the context of job applications that, marijuana testing that will not apply necessarily in other areas of the law. So I'll just give folks a minute here to review the list. If there's anything that you're not sure what that means or you want clarification on, just let me know. If there are no questions, we'll move to the next slide.
No questions.
So, who is protected under the employment law? These are the essential qualifications. They have to work in New York City. No, they have to work in New York City. It does not matter if they're a resident of New York City. They could be commuting from out of the city or even out of state, as long as their employment situation requires them to work in New York City. If that's where the discrimination occurs, they can file. The employer has 4 or more employees, so that's virtually all employers. Even most small businesses are going to have at least 4 employers. That's including the owner, the executive officer, etc. As I mentioned, the last incident of discrimination occurred within the past year due to the statute of limitations, with the exception of gender-based harassment, which is 3 years, in which case you can pursue a case in the state courts. How do we count who are the 4 employees in the company? The employers themselves, independent contractors, and freelancers would also be included in that calculation. Employers, parents, spouse, or domestic partners or child if they're working there. And the employees do not need to all work in the same location in New York City to make this calculation. So if I have 2 employees in Brooklyn and 2 employees in Queens, that's 4 employees. That entity is covered under the law. Something important about our law as well in employment is that we also have made a point to make the law as expansive and thorough as possible in order to capture as many different employment situations that exist. So interns are covered, whether they're paid or unpaid. Undocumented workers are covered as well. Part-time or probationary workers, domestic workers that work in the home, independent contractors and freelancers. All of these different employees, in different employment situations would be covered under the law. So just some examples of how this discrimination occurs. As I mentioned, hiring and firing. So even something as simple as, small differences in language on a job application could make the distinction between what is appropriate versus what is discriminatory. So in this example, a waiter or waitress with experience in Peruvian cuisine versus Peruvian waiter wanted. Subtle differences, but very key. Waiter or waitress, making the opportunity available to basically anyone regardless of their gender or gender identity, whereas waiter may be perceived as being male specific. Having experience in Peruvian cuisine versus being Peruvian, right? So I can be of any race or national origin, and I have experience in preparing this type of cuisine. The application makes that clear. Whereas in the second example, it has the connotation that I would have to be of a particular descendancy in order to qualify for that job. So these small differences that might not be even intentional in the language can actually be perceived as discriminatory and can result in a lawsuit. No criminal history would also be an example of discriminatory language, as it is illegal to discriminate on the basis of arrest record or criminal history record. Firing, so an individual as well cannot be fired on the basis of the protected class. Pay, so an individual cannot be paid differently for the same labor on the basis of a protected class. And as well, general other terms and conditions and privileges of employment, such as promotions, assignments, scheduling, or an availability of accommodations. As I mentioned, marijuana testing in employment is one of our newest protected classes. So as of May 10th, 2020, employers are not permitted to test job candidates for marijuana as a condition of employment. There are exceptions for particular jobs. There are exceptions for many areas of the law, and this is including one of them. And an important distinction as well is that this rule only applies in the application process. So employers cannot test an applicant. However, they can test their current staff if they had the prerogative. Salary history law. So this is an important one as well. This law was essentially created based on data which was showing that white men in the workplace were essentially earning more than their female or people of color counterparts doing the same work. That was partially because, you know, somebody may have their salary kind of lowballed early on in their career, and then progressively employers will learn what the previous salary was and offer them an incremental raise, which was still significantly below what the position was worth and, you know, truly the value of their labor, including, you know, taking into consideration their credentials. So essentially, the salary history law bans employers from inquiring about an individual's previous salary in their last job or in any job previously. They cannot ask you that in your interview. They cannot seek that information through a third party. They cannot look that up on the internet. They can contact your employer and ask about, you know, they can contact your references and they can ask about your qualifications and, you know, your performance in your previous job, but they cannot ask your employer either about what your salary was. If by happenstance they were to discover that information, they would be directed to not take it into consideration and to offer you a salary on the basis, again, of the value of the position, the labor that you would be performing, as well as your qualifications.
We have a question, excuse me, from Brian.
Sure, go ahead, I unmuted Brian.
Hey Ryan, can you possibly go back a slide, if you wouldn't mind, please? Yeah, this was, I mean, I'm one before that, sorry. This was all like super helpful information. I know definitely in my workplace, you know, we take this very seriously. I know recently it wasn't in my department, but I had heard it from another you know, leader within the organization. Basically, someone had sued because they felt that they had been wrongly passed up on a promotion due to a reason of being a part of a protected class. I don't really know the details of it or how, if it went any further or if it ended up going to court, they settled or whatnot. I don't know the specifics of anything that happened. My understanding, though, is when people, you know, raise this concern of being a part of a protected class and unfairly being discriminated in the workplace, it's hard to prove. And I guess I was asking your professional experience on if that's true, or, you know, if I'm a, you know, worker or something like that, and I feel like I've been wronged against as a protected class, you know, how do I go about, you know, I guess righting that wrong?
Yeah, so the first thing I'll say is I have my one-liner that I give in all presentations is, when in doubt, file a complaint. You may think that would be difficult to prove, but on the legal analysis of our attorneys, that may be something that we see that's actually commonplace. You may think that there's no evidence, but given our, you know, investigative mechanisms, our attorneys looking at the case may say, actually, we can uncover the evidence very easily. Or you may even have evidence actually without even realizing that that would be applicable in a court of law. And at the end of the day, because our services are free, you really have nothing to lose by filing a complaint other than 10 minutes on the phone. So for that reason, I always say, when in doubt, file a complaint, because every instance is different. There may be an instance in which, you know, what you thought was discriminatory, or what may very well be, you know, somewhat discriminatory in nature, may not qualify under the jurisdiction of the law, or, you know, discrimination may have occurred, but there may not be concrete evidence in order to prove it. But there's no way to know that unless we are able to have our lawyers put their eyes on it and potentially, you know, go through an investigative process. So when in doubt, file a complaint. That's number one. Number two, with regard to the difficulty of proving discrimination, this is a very lawyer answer, but it depends. It truly depends on the circumstances. It depends on the, you know, the nature of what has happened. It depends on if that's, you know, a wider practice and the same, you know, that same discrimination has occurred to other people who can verify that. It depends on whether there is documentation available. It depends on, you know, sometimes somebody says something discriminatory to you in an email and you have that email right there. That's pretty open and closed. But other times, you know, discrimination may have very well occurred, but, you know, the more incriminating conversations that may have occurred may have been off the record behind closed doors, and it can be very difficult to prove in those instances. So every case is different, but like I said, if you don't file a complaint, there's 100% no way that we can get justice for you. If you file a complaint, that opens the door to begin that process. So when in doubt, file a complaint. That's the message.
Yeah, I appreciate it. And I also have a follow-up, if you don't mind. So, and this was, I had asked this over the summertime from the speaker in the Small Business Committee. So obviously with COVID, we know that a lot of companies have gone fully remote. And a lot of companies, especially because, again, this is on the, the topic of scheduling here. Now that we're coming out of, this, normal or, what were the lockdowns in 2020, companies are starting to reopen. They're asking employees to return back to a workplace, either on a part-time basis or on a rotating basis, like we're doing at my job. But there are some people who are a little reluctant to that, especially who haven't been able to get, a vaccine. So I guess from both a worker and or an employee perspective, I'm sure you probably don't want to answer as an employee perspective. Is there any protections as an employee if, like, I don't want to go back to, the office because I'm scared of getting COVID?
Yeah, so I think the most important part here is remember that our law specifically deals with discrimination on the basis of a protected class. And I say that because there are many violations of labor law that occur, but that is not our jurisdiction unless a protected class is involved. So in the instance of COVID, there's the question of, is this employer being irresponsible and exposing all of their employers to risk by calling them back to the office for COVID? If that's the case, to me, that sounds like it could potentially be a violation of some labor code, but on face value, it doesn't sound like discrimination. Now, that being said, let's say somebody has a disability or that somehow constitutes a pre-existing condition. Right now, that person may be able to argue this is discrimination on the basis of my protected class because I have a disability. I am at heightened risk of COVID. So, this could constitute discrimination. I'm not saying that would necessarily be the case, but that's, from a legal framework, that could be a framework with which we might actually be able to bring that under our jurisdiction. So the primary question to ask in this instance is, number one, of course, the individual is going to be concerned about their health and safety. That's going to be the number one question. Do I feel comfortable exposing myself to this risk? Number two, if there is a violation of the law involved, do I feel like it is on the basis of a protected class that I belong to? And if the answer is yes, then that person should come to us. If the answer is no, and this is kind of a risk or liability that's evenly distributed amongst the employees, that may be something for Department of Labor.
Got it. All right. Thank you very much.
All right. You have one more question, Barbara.
Barbara.
Hi. Thanks. I have a couple of questions. First, I just want to clarify. Did you say you can't give drug tests anymore for an applicant before? What I've heard is you are hired. One last step is that you have to go through a drug test. Is that allowed or is that considered discriminatory?
Marijuana testing would be considered discriminatory in the application process. So it's specific to marijuana or marijuana related chemicals, which I don't know how to pronounce it, but I'll pull the screen back up. Actually, wait, no, it was ahead because we went back. So I'm not sure how to pronounce this word. I'm going to learn it and come back, but in the meantime, I'll let you read it here. So essentially, the test that is prohibited by the law is specific to marijuana and marijuana-related chemicals. So note that it does not say drug testing is prohibited. So employers may still be able to test for other drugs that are not marijuana-specific, but in the application process, it would be a violation of the law to test a potential applicant for marijuana or related chemicals.
A couple of other things. I know that a lot of employers go and look at your record. Do you owe a lot of money? Are you in default or things like that? Is that allowed?
No, and that's also in one of our next slides, which I'll be discussing in more detail.
And the other question I have, can you use the fact that, let me see if I can do this right. I know somebody that sued a couple of times, rightfully, for jobs. When she went for another job, they said, you have sued so many times. They found out, like it was a network of people that said that she had sued and she didn't get the job. Is that allowed also, information?
So I don't know how that type of information would be uncovered in the first place, but in the instance that an employer was privy to that information and decided not to entertain hiring that individual on that basis, that would also constitute a violation of the law, because that's retaliation. And individuals are protected against retaliation. That essentially means that I have the right to oppose discrimination. I have the right to pursue legal action to oppose discrimination. I have the right to file discrimination, even if I'm not sure whether it has occurred, even if the court ultimately finds that it wasn't discrimination, I still have the right to file a complaint and pursue justice when I believe that that's the proper course of action. And I also have the right to intervene on behalf of somebody else. If somebody else were to file a discrimination complaint, I can testify on their behalf, or I can testify that I experienced the same type of discrimination, or join their complaint. And individuals have the constitutional right to do all of that, and are protected against any form of retaliation that may occur against them in response, and that would constitute retaliation.
That's good. Thank you.
No problem. If there's no more questions, we'll proceed.
Yeah, you're good to go.
Sorry.
Okay, so salary history law, we've discussed this, so I'll kind of move through these slides because it kind of summarizes what I've already said. Pregnancy, childbirth, related medical conditions. So this is a protected class as well. So an individual cannot be discriminated against on the basis of being pregnant, having recently given birth, or having medical conditions related to either pregnancy or childbirth. There are accommodations that a person may be entitled to on that basis as well. So a person cannot be denied a job on that basis. They cannot be fired on that basis. If they currently have that job and they become pregnant or develop a related medical condition, they may be required, they would be entitled to an accommodation, such as, for example, lifting restrictions. If a person would normally have heavy lifting as part of their job duties, and now because of their pregnancy, they feel that that may constitute a risk to their health, they would be entitled to an accommodation where they could have a shift of job functions to not do that heavy lifting. Providing a seat for a cashier who has to stand all day would be another example, or providing additional bathroom breaks. A person claiming on the basis of these protected classes does not need to provide a doctor's note. They simply have to inform the employer that they have, are one of these statuses. And the employee has also the responsibility to provide a notice of rights. Even before an individual were to present, the need for an accommodation or anything like that, the employer has the responsibility to provide a notice of rights to all employees to make them aware of these rights. And this is the notice. Lactation accommodations are covered as well. So the employers must find a space for a lactation room and establish a written lactation policy. The lactation room must be a sanitary place other than a restroom that can be used for the following functions: to express breast milk free from intrusion. That includes at minimum an electrical outlet, a chair, a surface on which to place the breast pump, and other personal items in nearby access to running water. And also, in addition to the space, the employers must also provide a reasonable time for the employee to pump. The employer has to provide the space if one is not already available. And the written policy that they have to create should also be distributed to employees upon hiring. And the commission has actually published a model lactation accommodation policy and a model lactation accommodation request form. Gender identity and gender expression are also covered under the law. So transgender and gender non-conforming persons are covered under the human rights law. And in particular, these are topics that tend to come up a lot. So we specifically designate that these particular protections using the bathroom consistent with their gender identity. If an individual identifies as male, they have the right to use the men's bathroom. If an individual identifies as female, they have the right to use the women's bathroom. They do not need to show any documentation. They are not subject to any intrusive questions about their, physical health or whether they've undergone any type of surgery. They have the identity, they use that bathroom, open and shut, end of story. Using their personal name, title, and pronoun. So a person, may have a name, title, and pronoun that does not match their legal documents or does not match their birth certificate in particular. And they have the right to be referred to by that name, title, and pronoun, and a violation of the request to be referred to using that name, title, and pronoun would constitute discrimination. Dressing and grooming themselves in a manner appropriate to their gender identity expression is also covered. So if I choose to express my gender identity by using, a certain physical presentation or certain clothes, I have the right to do that, and my employer cannot tell me that, I cannot use certain types of clothing or present myself in a particular way. Now, that being said, all employees must present themselves in a way that conforms to the professional standards of the office. But within those professional standards, there's of course, room for gender expression, and the individual does have the right to express themselves within those standards. So I use the example of wearing heels. If there's a policy that says, I don't know, let's say a construction site. Let's say on a construction site, no one is allowed to wear heels for safety purposes. No one's allowed to wear heels at all. So that's fine. However, if there's an office environment, let's say, where certain individuals are allowed to wear heels, but then other people are told, oh, you can't wear heels. That's an example of discrimination because you're policing that person's right to express their gender identity how they see fit. That would be a violation of the law. So best practices, these are the best practices that we've established. So is the person's self-identified gender being respected? Avoiding sex stereotyping, and third-party bias or discomfort does not excuse discrimination. So those are just key points to keep in mind. We have a few videos throughout the presentation, but unfortunately, because of the the Zoom format, we are unable to show the videos. But they should be available on our website. National origin and immigration status. So these are protected classes as well. So as I mentioned, undocumented individuals are covered under the law, but we also have specific protected classes for individuals who are immigrants or undocumented as well. So all employees, regardless of immigration status, are protected under the human rights law. Workers cannot be paid less because of their immigration status. This is unfortunately another violation that we know occurs frequently, but is a violation of the law. Workers cannot be threatened with deportation. The workers are entitled to equal treatment, regardless of the language they speak, what country they come from, or whether they speak with an accent. And they can also not be prohibited from speaking the language of their choice on the workplace. So the question of credit discrimination. So credit discrimination, Stop Credit Discrimination in Employment Act is legislation which speaks directly to this. So it is illegal for an employer to inquire about any of the individual's personal financial information, whether that be credit score or any other information. And the reason for that is there's no objective data which indicates that a person's personal financial situation has any implications for their ability to perform the functions of a job. Furthermore, if an individual did have a troubled financial situation, they would of course have to have employment and be earning income in order to improve their financial situation. So essentially, by allowing discrimination on the basis of a person's credit score or financial situation, it's essentially punishing the person for being in a poor financial situation and preventing them from being able to improve themselves. So for those reasons, this would be illegal. And again, similar to the previous issues that we've discussed, such as the salary history inquiry ban, it's also illegal for the employer to, of course, ask you for that information, but also to seek it through any type of third party. And these are the summary. So the Fair Chance Act. We did mention that it's illegal for employers to inquire about, interactions with law enforcement or criminal history or arrest records. So the Fair Chance Act is essentially what covers that. So there's some kind of dense slides that kind of cover it, but I'm just going to explain it while we're on this slide. So as I mentioned, in many areas of the law, there are exceptions to this. So for example, certain city agencies or certain jobs will have exceptions where the employer can ask right off the bat on the application, do you have a criminal record? But for the vast majority of jobs on the market, it would be a violation of the law for the employer to inquire at any stage of the application process if you have a criminal record. Now, that being said, there is a stage at which the employer can inquire about that, but that's what we call the conditional offer of employment. So what that means is, as I mentioned, for the vast majority of jobs, that question cannot appear on a written application, on a paper application, on an online application. The employer cannot inquire during the phone screening. They cannot inquire during an in-person interview, and they cannot seek that information through any type of third party. Now, let's say the employer was to follow the law. They have not submitted any type of inquiry like that. And let's say I'm an applicant. The employer offers me the job. That's called a conditional offer of employment. They've excluded all the other applicants and gave me an offer. Now, I accept the offer. The employer can now say, okay, before we onboard you, before we formally take you on as an employee, now, with your consent, because they have to have consent as well, with your consent, we would like to run a criminal background check. And the reason is that now the question is not, do you have a criminal background? Now the question is, if you had a criminal record, does the nature of the crime committed specifically potentially create a liability for the job function that you would be performing? And to clarify that, I used an example of a bank teller. Let's say I'm applying for a job as a bank teller. I go through the exact situation I described. The employer inquires about inquires for the ability with my consent to search the background check. I consent, they do the background check. It turns out that I have a record for jumping a turnstile 3 years ago. There's no legal basis on which the bank can deny that offer because it's a very minor crime that a substantial amount of time has passed since then that I have not had any other interactions with law enforcement. There's no legal foundation on which they can deny me the job. They cannot say on the basis of this person jumping a turnstile 3 years ago, we don't feel that they'll be able to perform the functions of a bank teller. Conversely, let's say they ran the background check and it turned out that the previous year I had been fired from a job and also found guilty of embezzling money from my previous employer, so stealing money. That could be the foundation for a withdrawal of the conditional offer because having stolen money from my previous employer there could be a direct correlation to me now applying to a job being a bank teller where I would be handling large amounts of cash on a daily basis. That being said, if the employer did want to withdraw the conditional offer, they cannot simply turn around and say, oh, we changed our mind and give the job immediately to a different applicant. Because they've given me the conditional offer, they would have to go through what we call the fair chance process in order to withdraw the offer. And essentially what that means is, first, they'll have to provide me with information of exactly what they found and how they acquired that information. Then they would have to communicate to me that they intended to withdraw the offer and stating the reason for why they're doing that. From the point that I received that information, I have 3 business days to contest the offer if I feel that the withdrawal is not legitimate. And if I were to do that, and I couldn't come to an agreement with the employer, then I would have the right to file a complaint with the Commission on Human Rights. And we would be the arbiter who would ultimately decide whether or not the withdrawal was justified. So I know that's a lot of information, so I'll just stop there and see if folks have any questions or clarifications they'd like to make around the Fair Chance Act.
What happens if you're extended a conditional offer of employment and you don't consent to background
I see you have a hand from Barbara Rudder.
I think Sarah was asking a question.
Oh, was she? I'm sorry.
I think so. I'm sure.
Can
Sarah,
you hear me? It might be it might be my volume. Okay.
I can hear you now.
Awesome. Thank you. I just had to get in there closer. Thank you, Alexandria. Ryan, what happens if you're extended a conditional offer of employment and you do not consent to a background check? Either because you're concerned about what it might turn up, or if you're doing it in solidarity with other people who are subject to background checks.
So if you were to not consent to the background check, of course, the employer has no legal right to run a check. However, you would also understand that you're potentially forfeiting the position. Because as I mentioned, the employer does have the legal right to run a background check before they hire you. So if they're denied that right at that juncture, you may be forfeiting the position.
Thank you.
Okay, next is Barbara. Barbara has a question.
I think I'm unmuted, right? I know two cases like that. They were somebody was hired without revealing a condition they have, and when they did, they then demanded. One woman had some sort of back problem, and she needed them to buy a special chair and a special desk for her. Somebody else had something else where he needed to take naps during the day, and that wasn't revealed beforehand. It wasn't a condition that happened during the once hired. Does the employer have a right to let them go, or they can't?
So I think what you're speaking to is the issue of reasonable accommodations on the basis of a disability. Right. So that's a separate issue from the Fair Chance Act, and we actually are going to cover that in the next section of the presentation. So I'm just going to table that for one moment to see if folks have any questions specific to the issue of the Criminal Record and Fair Chance Act. And if not, then we'll get to your question in the next section.
Julia?
My question is not specific to this question, so I'm happy to wait, see if there's time at the end. Thank you.
Thank you. No more hands raised, so no more questions, it looks like.
Okay, so I will proceed. So this is just summarizing the information that we've covered. So this is one thing that I will also mention in addition. So just, taking into consideration as the employer, thinking about whether to withdraw the conditional offer or to give the person the job if it has been revealed that they have a criminal record. These are some of the things that we would want them to take into consideration. As I mentioned, the specific job duties. Is the nature of the crime committed? Does that have anything to do with the nature of the job? And do we feel that this person potentially poses a liability on the basis of, that specific criminal act and these specific job duties? Whether the criminal offense will have any bearing on the ability to perform the job duties, well, that's related to the similar idea. The time elapsed since the criminal offense. So that's another important one as well. Was the crime from 6 months ago or was it from 6 years ago? That makes a big difference. The age of the person at the time of the criminal offense. Sometimes the person may acquire a criminal record when they're, at a just more young, immature, less developed stage in their life. Now they're at a more, mature adult developed stage. They've undergone a personal transformation. The seriousness of the criminal offense. Was this a relatively minor offense, or was this, potentially like a more serious, dramatic, potentially violent crime? Any information provided by the applicant regarding habilitation and good conduct. So, sometimes an individual may also acquire a criminal record, a slew of offenses within a time period. They may be addicted to a substance, or they may be, experiencing homelessness or otherwise going some type of hardship, experiencing mental health issues, etc. So how has the circumstances of this person's life changed since that time period as well? And of course, taking into consideration the safety of the public. Caregivers. So caregivers are also covered under the law. How would we define a caregiver? A person who provides direct and ongoing care for a minor child or a care recipient, who could be a person with a disability, an older relative, etc. Now, caregivers are not necessarily entitled to accommodations on the basis of the law. However, what the law does indicate is whatever accommodations any other employee in the workplace would be entitled to, a caregiver has the right to those same accommodations. They cannot be denied an accommodation that other employees enjoy under different circumstances. So now we get to the question of reasonable accommodations, in particular with regard to individuals who may have disabilities. So reasonable accommodation essentially is an accommodation that allows the person to perform the functions of their job if they may not be able to perform those functions as easily as somebody else on the basis of their protected class. So an employee with a disability, as I mentioned, pregnant employees who are a victim of domestic violence, sexual violence, or stalking are also included here, as well as employees with religious observances. Now, we call it a reasonable accommodation because it cannot constitute an undue hardship to the business. What does an undue hardship look like? That's essentially something that would, so drastically affect your regular business and goings on of that entity as to make it, unreasonable for them to implement. So we determined that by essentially looking at the nature and cost of the accommodation, the financial resources of the company or agency. And we determined that by looking at various forms of documentation. So an example of an accommodation for someone with a disability, an assistive reading device for a low vision employee. In the context of pregnancy, as I mentioned, temporary reduction in lifting heavy boxes. A religious accommodation could be shifting a schedule to avoid conflict with a religious observance. For the victim of domestic violence, it could be relocating the employee for their safety. So just to answer the question of Barbara, so yes, an individual with any type of disability would be entitled to an accommodation in a workplace. If the employee did not provide that accommodation, then that would be a form of discrimination. Or if the employee was denied, if an applicant was denied a job on the basis of potentially needing an accommodation, that would also be discriminatory. I don't know if you have an additional question on the topic. Okay, great. Sexual harassment, also covered under the law. Sexual harassment being a form of gender discrimination, so that's the protected class that would be applicable. Gender discrimination when a person is treated less well because of their gender. The harasser can be of any gender as well. So, I mean, typically and perhaps most commonly, sexual harassment may take the form of a male harassing a female. However, it could be a male harassing another male. It could be a female harassing another female. It could take place in the context of anyone, anyone and any other person, regardless of their gender, gender identity, or sexual orientation. And in this case, when we define gender, that includes gender identity and gender expression.
We have a question from Bill.
Sure.
Bill.
Hi, I got a question. Assuming that someone has a disability, but for some reason this potential employee did not ask for this accommodation, but the employer knows that he or she needs the accommodation to perform the work. What will happen if that the employer provided the accommodation, the employee did not ask for it?
So if I understand the question correctly, it is, what would happen if the employee did not provide an accommodation knowing...
No, the employee did not ask for accommodation.
Right. So if the employer did not provide an accommodation knowing that the employee...
No, the employer did offer to provide accommodation, but the employee did not ask for it, and he or she may be offended or embarrassed. What the effect of this?
Okay, so that's an excellent question. I would say, so we actually have a presentation specifically about working with persons with disabilities, and one of the themes of that presentation is speaking to the specific issue of, what is the most appropriate way to interact with somebody that we may know has a disability or that we may suspect has a disability, but we actually don't know that. And one of those things is to, of course, not ask, probing or invasive questions or questions that may make that person feel uncomfortable or that may constitute a hostile work environment. Now, I would venture to say that offering an accommodation when one is not solicited could constitute, a similar type of hostile work environment. Now, if I'm in a position of the employer and I'm aware of the fact that an individual may be struggling to perform the functions of their job and I want to act in the interest of helping them, I would be very careful to navigate that conversation in such a way that takes that person's, feelings and potential interpretations of that offer into consideration. So to answer your question in simple terms, I would say that could constitute discrimination in the instance that it did constitute a hostile work environment in the perception of that individual who received that offer.
Let's assume what you just said. Okay. But if the employee is not being productive due to his limitation of his disability, the employer is out of good faith trying to encourage him or her, but is refusing, then the employer may have no choice but to terminate his employee for not being a productive employee compared to his or her peers. So without being hostile, work environment or discriminatory action will be terminated?
So it's very difficult for me to answer this question because we're speaking about the situation in general terms. And I think like in a situation such as this, which probably could be potentially very complicated and require us to look at specifics of the situation, you know, the specific productivity level of the individual, the nature of the disability that they may or may not have, you know, the degree of lack of productivity, and the nature of the dialogue that's occurring. I think all this would need to be taken into consideration to determine, you know, whether the termination would be a violation of the law or not. So, you know, I hate to give this answer, but I really can't say, you know, on face value, what yes, 100% that would or that would not constitute discrimination. Again, it's something that our lawyers would have to look at in the context of the specifics of the situation to make that determination.
So generally would be that just don't offer. It's up to the employee to ask for it or not.
Well, as far as the position of the law goes with regard to issuing an accommodation, the employer is not required to anticipate an accommodation that an individual may need. So if an employee does not request an accommodation, the employer could, you know, very well legally say, well, they didn't request an accommodation, so we didn't know that they needed. And even in this instance, they would probably use that argument. The individual's, you know, productivity drastically decreased. They never issued an accommodation. So as far as we know, you know, their productivity decreased. We didn't know they had a disability, right? Now, conversely, if the individual did state, I need an accommodation, and the employer did not provide it,
of course,
and then terminated the individual based on the rate of their productivity, that would definitely be discrimination. I mean, that's quite clear cut. But again, you know, in the instance, that's in the instance in which the individual requested the accommodation and it was denied. But so in the instance in which they do not request the accommodation, that makes the situation more complicated.
So going back to my initial question, is that when you say that an employer is not in a position to anticipate, but if he's able to anticipate, that will increase the performance or the productivity, and employees refuse whatever he or she feels, with usually anyway, that would be a discriminatory action if the employee was terminated because he or she refusing to accept the accommodation that may increase his or her productivity.
Yeah, so I can't really answer the question any further than I already have, which is that, you know, without more specifics on the situation, I really can't say what the position of our attorneys would be in the context of the law in that position.
Have you ever had, one last question, have you ever had from your experience in your office that people who with disabilities have a tendency who might be embarrassed asking for accommodation? And so they were reluctant to ask for it, and that may result in losing or terminating their position. Have you ever come across that in your office?
I am not personally familiar with any cases like that. But also, you know, because I'm with the Community Relations Bureau and not law enforcement, you know, it could very well be that that type of case has been received by the commission. I'm just not personally familiar with it. But unfortunately, I don't have personal knowledge of such a case like that.
Okay, thank you.
And Ryan, this is Sarah. To follow up on Bill's question, if an employer wants to do right by their business, right by their employees, can they go to the Human Rights Commission to seek counsel or advice on how to proceed if they're in a situation that's difficult to untangle and understand?
So the employer can come to the commission to inquire about clarifications about the law, but we cannot advise them on a particular situation. So they can come to us and say, hey, what's the commission's position on, you know, this type of disability discrimination in the workplace? and we'll be happy to answer them about the position of the commission in the context of the human rights law and our enforcement and our jurisdiction. Now, if the employer comes to us and says, hey, we're dealing with this individual in this particular circumstance, what should we do? We cannot answer that question. We don't provide legal counsel in that sense.
Got it. That's helpful. Thanks.
Any further questions here?
Not at the moment. You're good.
If not, we will fast forward back to the sexual harassment section. So just finalizing sexual harassment here. So, conceptualizing sexual harassment, it can look a wide variety of different ways. It is essentially any behavior that is offensive, threatening, demeaning, embarrassing, or something similar. So it can be physical, it could be verbal, it could be in an email, it could be a visual display. It can occur in many different manifestations, but when we think about, what is sexual harassment, this is how we would conceptualize that. And like I said, it occur in many different contexts. So transitioning out of employment into public accommodations. As I mentioned, public accommodation discrimination deals with services being rendered that are available generally to members of the public. So that could be private businesses, movie theaters, restaurants, banks. That could be a government-run space, such as a school, public transportation, hospital. Denial of entry on the basis of a protected class. Denial of service on that basis. Making an individual feel unwelcome or unwanted. All of these would be forms of discrimination and public accommodation. For example, we have heard of hospitals offering unequal quality of service on the basis of protected classes. A complaint that we hear from youth often is, youth of color being perhaps followed in stores on the suspicion that, they might be at a heightened risk of stealing something. All of these would be forms of public accommodation discrimination. And actually, since we were discussing disability discrimination as well, a public accommodation, like a store or other, again, place that should be generally accessible to the public, if it is not accessible to individuals with a disability, that would also constitute discrimination. And this is our list of protected classes here. Moving along. So just a few examples of the public accommodation discrimination. A taxi driver refusing to pick up passengers because of their race, a restaurant seating white families but telling a black family they have no tables available, a park preventing a transgender man from using the men's bathroom, a store targeting Black or Latino customers for shoplifting, a homeless shelter not accommodating a resident or prospective resident with a disability. These would all be various examples. So moving on now into the section on housing. So in general, when we talk about the human rights law in the context of housing, it is unlawful to discriminate in private and public housing, land, and commercial spaces. This means any person who is selling, renting, or leasing, including landlords, superintendents, building managers, brokers, and realtors, cannot discriminate because of a person's actual or perceived protected status under the law. Now note that we're not just talking about landlords. Again, we make the law as wide and thorough and expansive as possible in order to capture as many actors within the context of the housing industry as possible, because so many different actors can be involved, in discrimination in the various stages and processes of acquiring, living in, or leaving housing. Now there are, again, exceptions to the rule. So what are exceptions to the law? Two-family residence where the owner or members of the owner's family occupies one or more units. Rental of rooms in a housing accommodation where the rental is made by the owner and the owner or family member resides there. Housing limited to adults or persons with disabilities, older adults or persons with disabilities, as well as gender-specific housing. And this is our list of protected classes for housing. So again, who can be held liable? Landlords, superintendents, rental and managing agents, real estate brokers and agents, newspapers, So if a newspaper were to print discriminatory language issued by the landlord, they could also be held responsible. Lending institutions, insurance companies, and appraisers. So, information on lending, access to loans, appraisal of home value. These are all things that could be captured under the law as well. Lawful source of income discrimination. This is another important one as well. And actually, this is one of the most frequent forms of discrimination that we do receive complaints for. So it is illegal for a landlord to deny housing to an individual on the basis of them using any lawful source of income. So when we refer to lawful source of income, that could be money that I have earned through a job, through wages or salary. That can also be through a public benefit or a voucher or other program. So Section 8 being probably one of the most popular, but by no means the only. Section 8, city FEPs, HASA, GI related veterans benefits, all of these various programs that exist to assist individuals in paying rent and acquiring housing must be accepted by all landlords in all housing in the city. The landlord cannot say, we don't accept vouchers. The landlord cannot say, we accept certain programs, but not others. The landlord cannot say, we accept vouchers, but not for this building or not for this neighborhood, and steer you somewhere else. All of this would be a violation of the law. An individual seeking housing has the right to apply to visit and see, as well as to potentially live in that space free of discrimination on the basis of their source of income.
Wow, Ryan, that's really good information because it is happening still in the city, and a lot of people do not this commission. So this is really good, and definitely going to share the word. Alita Camp has her name up. I mean, her hand up. Sorry.
Hey, Sandra, thank you. Do you mind though if Bill Angelos goes first, since he's a member of the public, and I'll wait?
Okay, you were up first. That's why you had before, and then he put up.
I know,
That's
but
okay. Bill can
thank you.
go.
I don't mind waiting. Thank you.
Well, thank you. Appreciate it. Ryan, same question with employment discrimination. For employment, would your response be the same? Let's say, let's take, for example, a public accommodation. You know, the person disabled, but he or she needs accommodation, but he or she did not ask for accommodation. So would that be the same response for compared to employment?
Yeah, I would say that it would be the same response. For the individual who would want the accommodation, the most appropriate avenue for them would be to request the accommodation. The employer has a significant, plausible deniability if they have not been presented with an accommodation request and they have not provided it. So I would say, yeah, my response would be the same.
So generally speaking, that the person, the applicant, has to request accommodation for the entity, the employer, or public housing, whatever it may be, to protect, for the entity to protect itself for potential discrimination.
I'll say this as well. Anyone can file a complaint, right? So let's say I do not have a disability, but I notice that a building is not disability accessible. I can file a complaint myself and say, hey, this building is not accessible, and that would be sufficient to, under the human rights law. Of course, that entity would have to file the accommodation. But something important to mention, and actually this is important also generally to know across the board, the way the commission operates is we very rarely are proactive about investigating, or finding violations to investigate. Our model is what we call a complaint-driven model. So, of course, it's a city of 8 million people, right? So we receive many complaints. So we're constantly receiving complaints. So based on the sheer number of complaints that we receive, we have this model where we have a complaint-driven system. Somebody files a complaint to us, we respond to that complaint. So due to the nature of the number of complaints that we get, very rarely will we be proactive about discovering and proactively and investigating violations? So on that basis, we do encourage individuals to be proactive about filing complaints, because that's the best way to flag those violations for us. But again, in the context of disability in particular, I don't have to have a disability to file that complaint. I can just notice that an institution is inaccessible and file a complaint, and it will have the same ramifications.
I see. All right, thank you.
No problem. So just getting back to the levels.
Can I ask?
Oh, I'm sorry. Yeah, you had a question as well. Yeah, sorry about that.
Thank you.
So Lita could go.
Thank
Else is
you.
waiting.
Thank you, Sandra, and thank you, Ryan. So for someone who is renting a condo from the owner of the unit, does the anti-discrimination apply to that building if it involves access into and out of the person can't get in or out of the building, is in a wheelchair?
Yeah, so a disability access discrimination law is gonna pretty much apply universally across the board. So whether it's residential, whether it's commercial, whether it's public, whether it's private, pretty much all spaces have to be disability accessible. Now, the only exception to that would be an instance in which it was structurally not feasible to provide an accommodation. So let's say, for example, an individual requests a ramp, right? So let's say there's a step and an individual requests a wheelchair ramp. In certain instances, the sidewalk is so narrow that to implement the ramp on the sidewalk would actually take up too much space in the sidewalk and would violate the city's code for how much sidewalk space must be available for pedestrian traffic. So in that instance, it would not be structurally feasible to install the ramp. Another example would be if an individual requests an elevator. Many buildings in New York City are just very old and constructed at such a time that unfortunately disability access was not taken into consideration, and installing an elevator into that building would not be structurally feasible. So that would be another example in which again, it's a question of reasonable accommodation versus undue hardship. And in this instance, not only would it potentially be an undue hardship, it may literally be physically impossible without demolishing and rebuilding the building. So it's always that question of, as long as it's structurally feasible and physically possible to implement the accommodation, then they would be required to do it regardless of the legal status of the building. But if it was structurally unfeasible or constituted an undue hardship, then there would be an exception.
Yeah, this is not that case where it's structurally unfeasible. Did I miss it? Did you already say how to file a complaint?
I did not say it. So
Okay.
all of our contact information is going to come at the end of the presentation.
Okay.
So yeah, that'll all be there.
And how long generally is it between the time a complaint is filed and the time the commission is able to try and work on a remedy?
So generally, I'm going to put in the span of a few months. I'm going to put in the span of like 3 to 4 months from the time that somebody files a complaint to the time that, assuming it's jurisdictional, their case actually starts moving forward. That's not a hard, fast number. For example, in the case of lawful source of income, we actually have a specific unit that can address an emergency situation just because of the nature of acquiring housing. If an individual, there's a scenario that we see often. An individual applies to housing, the landlord says, oh, we have all these units available. How can we get you in? The individual reveals then that they'll be paying in whole or in part using a voucher. Suddenly the landlord says no units are available. We actually have a specialized unit for lawful source of income that will immediately, upon receiving that complaint, contact the landlord and basically do an emergency intervention to get that person into housing. So that's an exception where we actually have a rapid response team. For the vast majority of cases, it could take up to, it could even, I would put it up to potentially 6 months in certain instances. So it can definitely, again, due to the nature of the number of complaints that we receive and the backlog of cases that unfortunately exist sometimes, it can take over the span of a few months between the complaint and the case actually moving forward. And also, being resolved. I'll also mention, however, that that's also part of the function of the Community Relations Bureau. So unfortunately, we have heard as well that somebody may file a complaint, not hear back from an attorney, continue file up, and just be having a hard time, actually contacting someone, getting through the bureaucracy of the system. That's also another important function of the Community Relations Bureau, is that, so now the community board has my contact information, which, for the record, they can share with members of the public, so that anybody who wants to contact me, they can contact me directly. So if somebody files a complaint that is not hearing back, is getting frustrated by how long the process is taking, they can contact me directly as a member of the Community Relations Bureau and say, hey, on this date, I filed a complaint on this basis. I haven't heard back from anyone. What's going on with my case? I can follow up internally and make sure that an attorney gets back to them in a timely manner. So that's another function of our department as well.
Ed has a question.
Thanks, Andrea. Thanks, Ryan. This has just been really a great presentation. I was just asking Will in the chat if we have this deck on the on our site, and to follow up on your just completed point, having your contact info. Can we get a copy of this presentation for our website, because this is really good stuff, just for the public.
Yeah, so unfortunately, we cannot share the PowerPoint presentation itself, and that's due to the nature that, as I mentioned, the law is constantly changing and being updated, and so we don't want outdated information to remain in circulation. That being said, all of the most updated information, which is going to include the information in the PowerPoint, is available on our website. So on the website, essentially, there's fact sheets, question and answer sheets, press releases, case settlements that you can review, pamphlets, brochures, all the protected classes listed, contact information. You can even file a complaint directly through the website. So the website, nyc.gov/human rights, that is going to be the most important resource for viewing information that's here in the presentation, as well as how to file a complaint, etc.
Okay.
Are there any other questions at this juncture?
No, no. We're good.
Okay, so we are going to speed along because I do want to get through the rest of the presentation and allow more time for questions and answers. So GI Bill, this is also something important that we highlight as well, because status as either military service person or returned service person veteran is also protected class as well. So just examples of lawful source of income discrimination that can occur, what would be considered illegal under the law. Again, giving further examples: refusal to rent an apartment because a prospective tenant receives public or housing assistance, including Section 8. Refusal to process renewal paperwork. If I already have my housing, the landlord must process my renewal paperwork. They cannot deny that on the basis of my source of income. Refusal to do repairs for voucher holding tenants, but doing repairs for non-voucher holding tenants, that's also a violation of the law. Refusing to rent an apartment unless the prospective tenant earns 40 times the rent. So presumably, if a person is receiving a benefit that has a basis in their income, they wouldn't be eligible if they were making 40 times the rent, because they wouldn't qualify for the program in the first place. So that's an indirect form of discrimination. Print advertisements, including online or newspaper advertisements that indicate a refusal to accept vouchers or subsidies, and requiring credit checks when the voucher covers the entire rent and utilities. So the landlord can run a credit check if you're responsible for any portion of the rent. But if I have a voucher that covers 100% of my rent, then my income is not providing any percentage of the rent, and therefore the credit check is not relevant. Regardless of the number of units in the building, the landlord must accept rental subsidies if the apartment is rent controlled and the tenant lived there when the law took effect in March 2008, or the landlord owns another building in New York City that has 6 units or more.
We have a question from Rita Popper. Rita Popper has a question. Rita.
We lived in a Mitchell-Lama building, and we all received, when in buying out, what was called enhanced Section 8 vouchers. And it was made very clear by HPD that if you were to leave this building, that enhanced voucher reverts back to a regular Section 8 voucher. And it is up to the landlord of another building where you want to have an apartment if that landlord will accept the voucher. Is that true? Does he have to accept it, or it's his call?
So I'm not familiar, just being completely honest, I'm not familiar with this, I forget the terminology used, enhanced Section 8 voucher that's specific to the Mitchell Lama building. So unfortunately, I cannot comment on that particular specific subject, but what I am going to do is actually make a note about that and speak to my team, and I will get back to the community board. So I can't answer that question right now. What I will say is, under the jurisdiction of the law, as I mentioned, the denial of housing on the basis of using a voucher or benefit of any type would be considered discrimination. So on face value, my judgment is to say that that would potentially be a violation of the law. But again, because I'm not as knowledgeable about this specific type of program and potential legal limitations that it has, I can't say 100% that would be the case. But I am going to investigate it, and I will get back to the community board.
Thank you.
Ryan, I'm just going to interject for 1 minute. Our board member, Alita Camp, wanted to apologize that her battery died before when you were speaking. She thanks you.
I didn't quite hear what you said. I'm sorry. Can you repeat that?
Oh, sure. I said our board member, Alita Camp, wanted me to let you know that she apologizes that her battery died when you were providing an answer to her question just before.
Okay, not a problem. And I'm happy to repeat anything that they may have missed. So not a problem at all.
Sure.
Has a question. Strong.
Yes, hi. And thank you for the presentation, Ryan. I know of just last week where there was an incident with somebody who has mental health issues that has a voucher that was denied several apartments in several buildings in Manhattan, and they were told specifically that their buildings don't take vouchers. What should I advise them to do?
Yeah, so I just want to first comment that there are two types of discrimination happening simultaneously there on two different protected classes. So one is lawful source of income and the other is disability. Because our definition of disability does include, physical disabilities as well as mental, medical, or psychological disabilities as well. So if an individual was denied housing on the basis of any type of disability that they may have, as well as their lawful source of income, both of those would be considered discriminatory. As far as what they should do, of course, they should file a complaint. Now, that being said, I would actually recommend them to contact myself or another member of the Community Relations Bureau rather than simply file. They should file a complaint directly via the legal channel, which again, I'm going to provide that information at the end of the presentation. So they should file a legal complaint. However, it would be very helpful for them to follow up with either myself or another member of the Community Relations Bureau, because again, if it goes into the system, because of the backlog, it may take a while for that to actually be uncovered and reviewed and for that individual to be contacted, at which point it may be too late for them to actually get into housing that's immediately available. If they contact myself or someone else with the Community Relations Bureau, we can make that initial contact between that individual. We can flag that as an emergency and make that connection between that affected individual and an attorney. So that's a two-pronged approach. I would say number one, file that legal complaint. Number two, immediately file up with a representative of Community Relations so we can make that connection.
Okay, thank you. I appreciate that.
No problem. Okay, I'm going to continue here. So just reviewing general protections in housing. Housing seekers and tenants have the right to the following: buy, sell, rent, or lease housing without discrimination. See all available housing by brokers and landlords in the areas or neighborhoods they request. The same terms, conditions, or privileges for the sale, rental, or lease of housing. The same services or facilities as other tenants. To not be pressured to sell by exploiting ethnic, racial, or other demographic changes. And reasonable accommodations if they have disabilities. So again, defining disabilities here: any physical, medical, mental, or psychological impairment or a history of record of an impairment. A person with a disability must be provided with a reasonable accommodation. Again, defining reasonable accommodations, accommodating needs to ensure that they have meaningful access to enjoy a housing unit or public accommodation, can be structural, involving architectural modifications, or can involve policy or rule changes, and of course does not cause an undue hardship to the provider. Determining undue hardship, this is the same as in employment, the same criteria. Examples of accommodations, further examples: installing interior or exterior ramps at the building to provide wheelchair access, installing grab bars or handrails in bathrooms, permitting service animals, installing electronic doors, or permitting a tenant who has depression or anxiety to have an emotional support animal in their home despite a building's no pets policy. And this is just a before and after picture. Again, somebody who does not have a disability may not even notice that there's a step of maybe a couple inches, but that can be the difference between somebody having free access in and out of their home. So, you can see on the right, after the person made the request, the ramp was installed, and that's just, a happy ending, so to speak. So in the context of tenant harassment, again, it's just important that we are able to establish that connection, that the harassment that's occurring is on the basis of a protected class. Because again, we know that landlord harassment often occurs, but that harassment may be equally distributed to various tenants in the building, and the targeting may not necessarily be on the basis of their protected class. So harassment is always a violation of the law. The question is it a violation of the human rights law? And the answer to that question is going to be whether or not the harassment is on the basis of a protected class. Examples of discriminatory harassment in the context of housing that would be under our jurisdiction: intimidating tenants to move out of their apartments or surrender their rights because they're African American, failing to provide adequate heat because the tenant has children, failing to provide water because the tenant has a disability, threatening to call the police on immigration to force an immigrant tenant to vacate an apartment, threatening to assault a tenant because of their sexual orientation, or filing unfounded housing court cases because of the tenant's status as a victim of domestic violence to intimidate them into leaving the apartment. Just mentioning other protections in housing as well. Individuals seeking loans, mortgages, and credit are entitled to mortgages for which they qualify, information about loans, and the same terms or conditions for a loan or credit card as other customers. So that is the end of the section on housing. Moving into discriminatory harassment. As I mentioned, when we talk about discriminatory harassment, that's essentially violence or the threat of violence or intimidation or any type of interference with the safe enjoyment of an individual's constitutional rights on the basis of discrimination. So essentially, that's too text heavy. There's also a fine line I'll mention between what is considered discriminatory harassment and what is considered First Amendment protected free speech rights. So an individual may make a statement that is unfortunately prejudiced, biased, hateful, but not necessarily a violation of the human rights law. It becomes a violation and moves into the realm of discriminatory harassment at the juncture that I feel threatened or intimidated, or that person is attempting to, again, interfere with my exercise of my constitutional rights. So if somebody were to make a statement, I use the example of myself being Italian American. If somebody were to make a statement saying, I hate Italians and I wish Italians would leave America, that's a hateful statement. That's a prejudiced, biased statement, and a very unfortunate statement. However, that statement is covered by the First Amendment free speech rights of the United States. Now, if that person were to escalate that statement and say, I hate Italian Americans, and because you're Italian, I want to hurt you, that has now moved into the realm of discriminatory harassment because they have threatened me with violence. The same would occur if they were to approach me in a threatening way that made me feel unsafe, or if they were to, again, block my access or in any way try to interfere with my constitutional rights, or of course, if they were to physically attack me. Unfortunately, in the context of COVID, and stigmas related to COVID, specifically with the Asian American and Pacific Islander community, we've seen a huge increase in discriminatory harassment against people of Asian American and Pacific Islander descent. So those are examples of discriminatory harassment as well, which be covered under the law. So that's always that question that we bear in mind. Because of that line between free speech and discriminatory harassment, that's always the question that we have in mind. Is it just that somebody made a discriminatory statement, or does the nature of that statement combined with this person's behavior violating the human rights law because it's threatening or intimidating me or interfering with my rights? So, just some additional things to keep in mind. A pattern of threatening verbal harassment, use of force, intimidation, or coercion, defacing or damaging real or personal property. That's also something, unfortunately, that we see, and cyberbullying as well. And finally, just mentioning bias-based profiling by law enforcement as well. Under the human rights law, it is illegal for law enforcement to enforce the law in a way that violates a person's rights by targeting them on the basis of their protected class. That would include, targeting particular communities for law enforcement. That would include using prejudiced language while carrying out law enforcement duties, etc. As I mentioned, retaliation is covered under the law. Everyone has the right to oppose discrimination, to report or file a complaint of discrimination internally within their organization or externally, or to cooperate, assist, or participate in an investigation, proceeding, or hearing related to violations of the law. With regard to what do our lawsuits actually look like? What do the settlements look like? The commission can impose up to a $125,000 fine and civil penalties for violations, and up to $250,000 for violations that are the result of willful, wanton, or malicious conduct. In other words, let's say a small business violates the law without realizing that that act is against the law. We're not looking to punish that small business and put them out of business with fines. We're looking to, again, get justice for whoever maybe have been discriminated against, and also make sure that if that entity is participating in good faith to correct those practices and move forward with more, socially just and equitable policies, that's our primary concern. However, if we were to see an entity, for example, such as some landlords who are knowingly and willfully engaging in discriminatory processes, some of which have said over the phone directly to our attorneys, we don't care if we're violating the human rights law, we're going to continue this practice. That's a much different context with regard to enforcing the law and issuing fines. So we're looking at, the nature of the violation of the law as well. And of course, these penalties are in addition to other remedies. So ordering the provision of an accommodation that may have been denied, mandating to attend a training, entities that are found essentially guilty in the court of law of committing discrimination must undergo trainings such as these that are actually more geared towards knowing their obligations rather than their rights. Back pay to individuals, emotional distress damages, or other out-of-pocket expenses that may be related to the incident of discrimination. And again, we also take more of a restorative justice framework as well. So, one instance that I really like to talk about is an instance in which, so we actually have one of our legal guidances clarifies that discrimination on the basis of natural hair or hairstyles traditionally associated with the Black community is tantamount to racial discrimination. That was the result of, various stories that we had seen not only in New York City, but nationally of individuals being discriminated against on that basis. So there was one instance of a salon in the Upper East Side, which had threatened to terminate 2 Black employees who were wearing natural hairstyles if they didn't change their hairstyles to what they deemed was more appropriate or professional, in other words, which is more Eurocentric. So those individuals filed a discrimination complaint. They actually won their complaint. They did receive a settlement, but in addition to that, there was other remedies that we took. So the salon, all of the employees of the salon were instructed to undergo trainings to be able to style natural hair as well. So expanding their clientele to not be discriminating against who could receive their services. The owners of the business had to volunteer with organizations that worked in the area of racial justice and hair discrimination in particular. And also the business was instructed to create new opportunities for individuals looking specifically to do salon work for natural hairstyles. So again, we're not just looking for we are primarily first and foremost looking for justice for the individuals, but we're also looking to, number one, make sure that that change is sustainable and will not affect other individuals moving forward. And number two, create a cultural shift that is more in line with those values of, pluralism and multiracial democracy that, again, we were really pointing to in the beginning of the presentation. So that's just an example of the more creative remedies that we may adapt as well. And finally, the information everyone's been asking for, our contact information. So you can contact the commission by dialing 311 and asking for the Commission on Human Rights. This is also our direct line, 212-416-0197. Our website, which you see here, nyc.gov/humanrights, has a plethora of information. I highly recommend visiting that, seeing the information that we have available there. You can file a complaint by calling the number or by going on the website and submitting an online form. And we have, as I mentioned, frequently asked questions, documents, legal guidances, one-pagers, informational pamphlets and brochures about each specific area of the law, and it's all available in various languages. The commission staff itself, just amongst our own staff, speaks over 30 languages. And in addition, if we didn't have somebody on staff who spoke the language, we do have a telephone interpretation service. So anybody, regardless of the language that they speak, would be able to access our services. So with that said, I will stop here, allow more time for questions and answers, and I will also put my own personal contact information in the chat.
Thank you. I have a question really quick. Have you all taken any cases with public housing residents?
So,
York City Housing Authority?
Yeah. So that is a much more tricky area. And the reason is that because of the nature of NYCHA kind of being structurally split between federal and local entities, it's very difficult as a city agency to successfully bring a case within the jurisdiction of our law, which is, city specific and ends at that level. So again, I would stick with the same principle of when in doubt, file a complaint. But the reality is that bringing cases against housing authority is substantially more difficult than other landlords.
Okay. Bill has a question.
Thank you. Like I said, Ryan, it's a great presentation, very informative. Just a question. I'm not quite sure, please correct me. It's my understanding, in the employment discrimination, the Commission on Human Rights, the New York State Human Rights Division, or the EEOC, do they refer cases to one another?
I don't think so. I don't think so. And the reason I would say that is because, as I mentioned earlier in the presentation, an individual essentially has the opportunity to file one legal case with one of these entities. So in other words, I cannot file a complaint with the Commission on Human Rights, see the complaint through, not have the ruling in my favor, and then file with the state, and then file with the EEOC. I would essentially have to choose where I was going to file my complaint, and then pursue that to its logical conclusion. To the extent with regard to referring complaints, I've never heard of that happening, and I think that's just because of the drastically different jurisdictions and legal realms within which these entities operate. So for the individual who wants to file the complaint, I would just recommend before filing, really doing your homework about, exactly what your context is, exactly what your situation is in the context of the law that each of these entities is enforcing. But that being said, again, I personally recommend, not that I'm biased as a representative of the commission, but I do recommend coming to the Commission on Human Rights because our law truly is one of the, if not the most expansive and thorough civil rights legal codes in the country. So protected classes that exist under the city human rights law are not necessarily going to even exist on the state and federal level. So the most probable way that your case will be accepted is filing with the commission.
Okay, thank you.
Ryan, if I may follow up on Bill's question, given the limited time of the statute of limitations, it seems that with some of the issues that take more time to uncover, that the statute of limitations may preclude pattern or practice type of lawsuits. And so is that one of the things that a person would do in kind of contemplating where they're going to file their complaint? Like the impact of statute of limitations?
Yeah, so not necessarily. So assuming that I understand your question correctly, I just want to clarify one thing, which is that, as I mentioned earlier in the presentation, the last instance of discrimination has to have occurred within the 1 year. So you could have been in the workplace for the past 10 years and you were consistently experiencing discrimination. As long as the last instance of discrimination happened within 1 year, that whole 10 years of discrimination that you experienced would be taken into consideration in the context of that complaint. So, there's no limit to how far we can go back into the investigation and what we can take into consideration at taking into account the pattern of the practice. So only the last instance has to occur within the past year. So it's not within these 12 months. That's all we can think about. It's wherever the last instance occurred, and then we can go back from there, if that makes sense.
Yeah, that's really helpful. That's exactly what I was trying to get a sense of, is whether or not the previous incidents leading up to the one that was reported would be taken into consideration. So thank you.
Yeah, they absolutely are. Yes, definitely.
Okay, I don't see any more hands raised. If anybody else have any questions, but thank you for the great presentation. It was very informative. Definitely an overview. It's still a lot to ingest. I remind everyone on the Zoom that this is recorded, so you can always go back and look at it on YouTube to revisit it. Definitely. Yeah, so I'm looking again one more time for more hands before we move forward. Any other final words you want to say to the board, to this committee rather?
Ryan, did you say you sent your contact information?
Yeah, so I was actually gonna bring that up. So I'm clicking on chat and it's not appearing. I'm assuming that's because I don't have the authority, digitally on the call to actually open up the chat myself. So
you can share it with me if you want. I'm Max, and you can share it with me, and then I can share it with everyone if you're able to do that.
Yeah, so I'm not, like, when I click chat, the chat box doesn't appear at all, so I can't even message someone privately. I think if someone were to message me, the chat box will appear and then I can respond to it, but it doesn't appear that I can actually open the chat box at all.
Okay, I just sent you a direct message in case that's helpful.
Okay, it doesn't appear I've received it yet. But in any event, oh, there we go, perfect.
Yeah, because it's set up so you can just communicate with the district managers. So
okay, perfect. Yeah, here we go. Let me.
Got it. Okay, thank you. I will share it.
Alita Camp has her hand up.
Oh, yep. Go ahead, Alita. Sorry.
Thanks, Sanjay. I just wanted to say that this is really useful and very helpful because a lot of people are not. I know I wasn't so familiar. I have done work with the EEOC on the federal level, but the breadth of the Commission on Human Rights is really it's broader, and so I think this just brings a lot of information to people about what to look out for and what kinds of things are covered under New York City law. Once again, showing how intentionally interested in bettering the quality of all of our lives, the city and all of the people on the board are. So thank you for coming, Ryan, and for Sandrea and Sarah. I don't mean to sound odd, but I just think that this is so much broader and deeper than what I think a lot of the public knows about, and making it really useful. Thank you.
Thank you. Sarah, you want to pick up?
No, go ahead. I guess we have to go through ask about old business and new business if no one else has questions. But before doing that, I also want to thank you so much, Ryan, for this. You weren't kidding. It was very dense and jam-packed with information, and I'm glad that we can refer to, and we will probably be linking to various parts of your website in order to make sure that we can get as much of this information out to our community as possible. So thank you so much.
It's my pleasure. Thank you for having me.
All right, I'm throwing it back to you, Sandra.
Okay. Do we have any new business? And thank you again. I'm sorry, Ryan, once again, thank you. Do we have any new business? Go to old business. Any old business to bring up? Okay. Well, if we do not have any, hope I'm doing it right. If we do not have any old and new business, someone could motion for us to close, to adjourn.
I see Russell and Barbara. Oh, and Rita.
Okay, I hope I did it right, but
You did. You did.
okay. Okay. All right. Good night, all. Great meeting and great attendance. Thank you all.
Great. Thank you.
Good night, everyone. Thank you.
Good night. Good night.